Without further delay, I would like to introduce Professor James Turk, who is an academic and director of the Center of Free of Expression at Toronto Metropolitan University. He's a frequent media commentator and public speaker on freedom of expression, intellectual freedom, post-secondary education, academic freedom, and other public policy issues related to expression, freedom, social justice, and democracy. And without further delay, I pass it on to Dr. Professor Turk.
Thank you very much. It's a real honor to be here, Khaled. I'm grateful for the invitation to join you, and I want to congratulate you and your organization for the leadership role you played in trying to block this bill and trying to at least get it amended in useful ways. Without your leadership, much of that would not have happened, so we're very grateful for
Thank you.
that. And that's important, and because what I really want to share with everyone tonight is it's a very bad bill. It's a bill that's dealing with an extremely important problem that we have in our society, and that is hate. And it's a bill that's supposed to try to deal with the increasing amount of hate crimes and the problems that a number of marginalized communities are facing. Yours is one of the major ones, but it goes about it the wrong way. And on balance, I think will make the problems worse rather than better. And what I'd like to talk with folks tonight is what some of those things are. And I think the way this platform is set up, there's an opportunity for people to ask questions. Is they're not using the Q&A button that they would see down at the bottom of their screen. And so what I'd encourage people to do is if you have questions for me while I'm going through this, you don't have to wait till I'm finished or till the end of the thing. You can write down your questions on the Q&A, click on the Q&A button and write down your questions as you think of them. And then at the appropriate time, Khaled will bring us back to deal with the questions. But that way you can write down your questions while you're thinking of them. So what I'd like to do is share with you a brief description of what I think are some of the serious problems with this bill, which is now law in Canada. There are three major parts I'm going to talk about and a fourth additional one. So one part of the bill, section 4 of the legislation, is to deal with the willful promotion of hatred. Already in our criminal code, we have two provisions dealing with hate speech. One is section 319.1, which defines hate speech as that which occurs in public. It involves making hateful comments about an identifiable group that are likely to lead to a breach of the peace. That's a very high bar. And so there have been very few prosecutions under that. The second existing provision is section 319.2, which is the willful promotion of hatred. And our courts have spent a lot of time trying to spell out what the willful promotion of hatred actually means. What this bill does is adds an additional basis for charging someone with a willful promotion of hatred. It says, and I'll just read it, it's quite short. Everyone commits an offense who willfully promotes hatred against any identifiable group by displaying in any public place a symbol that is principally used or principally associated with the listed entity defined in a subsection of the criminal code. Now in Canada, the government can designate terrorist organizations and put them on a list. And so it's referring to that. So any symbol associated with any group on that list, and I'll come back to that in a minute. Secondly, by displaying the Nazi Hakenkreuz, which most people refer to as the swastika, but because in the Hindu religion and some other, there's the same symbol turned a slightly different way. They took swastika out of the language and used the German term for what the Nazis called, as well as the Nazis signed the double bolts, the SS bolts, And then the parliamentary committee considered this, made a motion to also include the noose. So any signs associated with any of the groups on the terrorist list, these two symbols of the Nazis as well as a noose, and then thirdly, a symbol that so nearly resembles a symbol described above that it's likely to be a symbol, so a symbol that looks anything like these symbols. So what it says is everyone who commits an offense who willfully promotes hatred by displaying any of those symbols in a public place. Now, there are problems with that, and problems that I think are going to come back to haunt most of us in most marginalized communities. Because, first of all, what gets a group listed on the terrorist list is an uncertain and political process for which there is no right of appeal. It's an arbitrary process. Many of the groups on it are genuinely groups of concern, but groups can get on it for a variety of reasons and political reasons. And so what this criminalizes is if you have a symbol of any of those groups, then you're deemed to be engaging in the willful promotion of hatred if you just display the symbols. Secondly, it's said that any symbols that look like those symbols. So what in practice you're doing if there's a protest and there's a group of people with a variety of flags and symbols, and many of these symbols look somewhat alike, and some are on the list and some aren't on the list, you're giving police the authority to use their judgment as to what's the contravention of this legislation. I doubt if any police or any of us could tell some of the fine distinctions amongst flags or representations. And we've seen how in the prosecution of Palestinian protesters, all sorts of symbols, cafes, various flags and so on have been used, or claims have been used. So it creates a lot of uncertainty, and it opens the door to a lot of police discretion as to who gets charged. But there's a second problem with these symbols is there were efforts made, and I think, Khaled, your organization was one that was trying to do that. And that was that the legislation says that you're committing the offense by displaying these symbols. So again, willful promotion of hatred against the identified group by displaying the symbols. So it's the displaying the symbols, doesn't matter what you're doing. It can be a peaceful protest. If you have a flag that's on this list, you can be charged with a hate crime. Now, there were efforts by some organizations to amend that. So it said it's the willful promotion of hatred while displaying these. That is, displaying it wasn't the willful promotion of hatred, but it made the offense worse by doing it while you were displaying these symbols. And the parliamentary committee and the parliament did not accept that amendment. So now we're in a situation that simply having a flag or simply having a symbol that looks like a flag associated with a terrorist organization on this list is violating the criminal code. That's unprecedented in Canada, and I think may well be able to be challenged under our charter. Okay, so that's the first thing this bill does. It creates this new definition, which really doesn't help us at all in dealing with hate crimes, but makes a lot of people engaged in protests against various kinds of behavior more vulnerable to being charged. The second change is that, and this is a major one, this bill creates a new hate crime. What it says is everyone who commits an offense under the criminal code who is deemed to be doing it out of a motivation for hatred is creating a second offense. So I'll just read you the wording. It's short. Everyone who commits an offense referred to in this section as an included offense under this act or any act of Parliament if the commission of the included offense is motivated by hatred based on race, national or ethnic origin, language, color, religion, sex, age, mental or physical disability, sexual orientation, gender identity or expression, is guilty of an indictable offense and liable to a punishment that is actually more severe than the original offense. So let me give you an example. If I'm robbing a store owned by a member of a religious group and it's deemed that I hate that religious group, and therefore my robbing the store that's owned by this store owner who's from that group, they deem I'm doing that because I'm motivated by hatred, then I'm guilty of robbery, and I'm also can be charged with a hate crime for undertaking a robbery motivated by hate. So there's two crimes now. And the penalty for the second crime, in each case, regardless of what the second crime is, what the first crime is, robbing the store, the penalty for the second crime, the hate crime, is more severe than the penalty for robbing the store. So what's worrisome, there's a lot of things worrisome about this, but it's this wording that anyone who commits an offense under this act, referring to the criminal code, or any other act of parliament. So that means if I litter in a national park and I'm throwing away stuff and they say, well, you're throwing away, you tore up a religious document issued by a group you hate, and you littered in the park, I can be charged with littering, and I can be charged with a hate crime for littering because I was motivated in doing the littering by hatred of a group. And I can be sentenced to extra years in prison for the second crime, in addition to whatever penalty there is for littering. So any act of parliament. Now, the list of acts of parliament other than the criminal code is very, very long. I won't go through them all. So this just creates an enormous wellspring of litigation, of court cases. So you're going to have the original crime, the robbery, the littering, the shoplifting, or whatever. And then you're going to have the second crime, the hate crime, because you were motivated by hatred in doing the first crime. So the courts are going to get clogged. Prison times are getting greater. And there was no need for any of this, because in our criminal justice system now, if you commit a crime motivated by hatred, that becomes a factor in your sentencing. So if I rob a store and they're able to show in the court that I was motivated by hatred of a person because they were Jewish or because they were Muslim or because they were Christian or whatever, then when I go to be sentenced, my sentence can be extended by the judge because it was a crime motivated by hate. That system worked pretty well. What's proposed here, in my view, is a little bit crazy. It essentially achieves the same end, but it means now the court there have to be two separate court hearings, two separate lawyers associated with it, twice as long. It clogs up the court, but it also gives the police the right to make the judgment as to whether you were motivated by hate. Whereas under the current system, you have to persuade the judge in the court that it was a hate crime. That it was motivated by hate. Whereas here, you can be charged, you can be labeled as a person who's engaging in hate, and you can go through that long before you get to court. So, I just think, I live in Toronto, and there have been lots of pro-Palestinian protests in a part of Toronto that has a fairly large Jewish area. And there's been great outrage that these perfectly legal protests on public property are hateful. Now, with this additional bill, it's possible for the police to say, well, yes, they're engaging in nuisance, which is a violation of the criminal code. They're motivated by hatred, and so therefore we're going to charge them with nuisance and we're going to charge them with a hate crime. So it gives lots more discretion to the police, whereas under the present system, if the people who were protesting were charged with nuisance, the whole business of the hate crime only comes in the latter stages of the court case. So this gives a lot of discretion to going after people, increasing the penalties, and it doesn't achieve anything that isn't achieved under our current system. The third part of the problem is one that concerns me particularly. You may have heard of something called bubble zone bylaws. A number of communities in Canada, Toronto is one of them, the city of Vaughan is another, the city of Calgary is another, Brampton, Ottawa, were persuaded that largely by pro-Israel organizations, that there had been lots of protests at synagogues, at other places associated with the Jewish community, community centers and others, that shouldn't be allowed to happen. That people are being prevented from going into worship in a place of worship, that they're being prevented from entering a building that's a cultural center, or there's protests outside a childcare center, and all of this blocking people from going in, threatening them, threatening violence against them, has to be stopped. And the way to do that is to pass a bubble zone law, which says that there is no protest allowed within a certain range of distance from these buildings. So the first bubble zone law was passed by the city of Vaughan, which said you can't have any protest within 100 meters of a place of worship, a child care center, a community center, and so forth. Now, the difficulty with this is that kind of a law, a municipal law, is either unnecessary or unconstitutional. Everything that they object to in advocating for this law, and I'll get to it, it's the same thing for this, what the federal government has now done in Bill 9, C9. Everything is already illegal. It is illegal in Canada to block somebody's entry to a church, a synagogue, a temple, a mosque. In fact, it's a violation of the Criminal Code Section 430 to block their entrance to any building. So it's already against the law. And so if what they're doing is simply trying to prevent you from blocking entry or threatening someone with violence if they go in, or harassing them as they go in, there's no need for that. It's already illegal in this country. What the bill that the federal government brought in C9, the third provision of C9, is to introduce into the criminal code the same kind of bubble zone law. Specifically, it says every person commits an offense who, without legal authority, intentionally obstructs or interferes with another person's lawful access to a building or a structure, or a part of a building or a structure, referred to below. And the institutions referred to below are a place of worship, a school, community center, or child care center, or seniors home associated with a particular group based on religion, race, sexual orientation, or whatever, or a cemetery. So if you willfully obstruct anyone going into one of those, you're now guilty of a criminal offense, but you're already guilty of a criminal offense under Section 430 of the Criminal Code. But what this adds is an additional problem with doing that, and that is you're also, I'm sorry, let me just get the exact wording here for you. I want to be precise, sorry. In addition to not being able to obstruct, it says every person commits an offense who engages in any conduct with the intent to provoke a state of fear in a person in order to impede their access to a place of worship, a community center, and so on associated with a religious group, or a cemetery. Now, that would mean that if there were an event going on, I'll just take an example that actually occurred in Toronto, which was widely reported. There was a synagogue in Toronto that hosted an event one evening that brought real estate companies in that were selling land in the occupied territories in violation of international law of which Canada is a signatory. And there were protests outside because of that. That's the kind of protest that is trying to be disallowed. Now, if I had been at that protest and somebody was going into that, I can't block them from going in because it's already against the law. But I can yell, shame, it's disgusting that you're going to this. It's disgusting that they're violating international law. I could be charged. Somebody could say, well, Turk, you were yelling at us, shame and so on. It made me fearful. So I provoked a state of fear, which is now a violation of the law in Canada. That's a real concern because I think that's a clear violation of the Charter. And I think a number of our organizations are going to look to bringing a Charter challenge the first time someone's in charge, engaging in a peaceful protest, saying shame, or it's disgusting that you're going to that meeting, or shame on you, and is charged under this bylaw. So not under this bylaw, under this provision of the law. So this law is again adding nothing helpful because everything other than provoking a state of fear is already illegal in Canada. And provoking a state of fear is something, presumably, if you're doing it without harassing them, without threatening them with violence, without having a weapon or whatever, which is all those things are illegal. If you're doing in a perfectly legal way, you're protesting, you can now be charged. Furthermore, that kind of wording is going to have a chilling effect on legitimate protest. Now, they could have written this law much more narrowly. They could have, and a few of the municipal bylaws have been more narrowly written, that they only apply to a place of worship when it's engaged in worship. It only applies to a school during school hours, because all sorts of organizations can rent a school to have a political meeting, or can use a place of worship for a political meeting, or engaging in a political activity that's not religious worship, but propagating various ideas that may be highly controversial, and whether members of the faith want to protest. It also could be that these places employ staff who go on strike, and there's no exception or permission in the law that would allow strike pickets or protests of that sort. So this third provision introduces an unprecedented limit on legitimate protest in Canada that will chill a lot of people from engaging in protest, will be worried to go to protest. So if there's another if there's another synagogue that invites in people selling property in the Palestinian territories, a number of people may be now fearful of using their legitimate right of protest. Or there could be Christian churches that, as we're seeing in the United States, that are advocating some truly reactionary policies that are arguably illegal, that I may want to protest. And now I'll be told, well, if you protest because it's a church, because of this law, even if you're engaging in peaceful protest, you may be creating a state of fear and therefore can be charged under this law. And the penalties for violating this law are the standard hate provision penalties in Canadian law. So that's a third really worrisome thing that applies everywhere in the country. So those are the three major provisions of the law. None of them advances protection, real protection against hate. All of them have a chilling effect on protest, and all of them arguably make us more vulnerable to police discretion in shutting down protests than we were before. Now, there's one, if I may, Khaled, there's one additional bit of the law, um, is that there were various attempts to amend the law. And I just want to give you a sense that the criticisms I'm making of the law were made to the parliamentarians, and they were given a chance to fix those things. That is, to keep the law they wanted, but to get rid of these really harmful aspects of it. So your organization, Khaled, I believe, made an amendment, brought forward an amendment to clarify that in terms of religious symbols and so forth, that any foreign language text or religious scripture cannot alone constitute a hate symbol. The use, quotation, display, or reproduction of text written in a foreign language or derived from religious scripture should not be considered a hate symbol within the meaning of this section. And that was rejected. So they know what they're doing. There was a further attempt, as I mentioned earlier, by the Canadian Civil Liberties Association to say that the displaying of one of these symbols in itself is not the willful promotion of hate. What would be illegal is if you're displaying it while you're engaged in the willful promotion of hatred. In other words, replacing by showing the symbol, but while showing the symbol. Parliament rejected that. There was an attempt to get the new hate crime provision that while you're engaged in one offense against anything in the criminal code or any act of parliament, you can be charged. If you're motivated by hate, you can be charged. The Canadian Civil Liberties Association tried to limit that just to offenses of the criminal code if you're robbing somebody or you're engaging in assault that's motivated by hate, but not if you're littering in a national park or the thousands of other non-criminal code provisions that are acts. And they said, well, it should only apply to the criminal code. That was rejected by the committee. So, I mean, there's just a consistent pattern here that, let me just say one, I'm sorry, I wanted to add with regard to amendments that were made to the bubble zone provisions. There was an attempt to make them clearer and less broad. One amendment that was put forward by one of our groups was nothing within this provision shall be construed to restrict the right to lawful assembly or expression. This provision shall not be interpreted, in other words, the bubble zone ban should not be interpreted to apply in any way that prohibits, limits, or criminalizes lawful and peaceful protest, demonstration, picketing, or expression, including peaceful activities occurring in proximity of places of worship or religious schools. So as long as it's peaceful, it would be fine. The committee rejected that amendment. And then finally, there was an amendment that the offense established under this section applies only in respect to conduct that intentionally obstructs or intimidates a person seeking to attend or participate in religious service. This offense does not apply to non-religious activities that take place in these same locations. So again, the examples I gave, if there was a political meeting in a school or a selling of land in violation of international law, you couldn't be charged with an offense if you're protesting that. They rejected that amendment. So they left it deliberately broad. They left all of the bad sections in that I've been talking about. And now we have the challenge of what do we do about that? And I think you're going to be addressing that. And I've given a little foretaste of some of the things I think we're going to be doing. So I don't know if there's, whether you want to deal with questions about that now, or we can come back to what I was saying about questions later. I'm happy to do it however you'd like, Khaled.
Thank you, Jim, for this thorough presentation. We have I actually want this to a bit more dynamic as you suggested in the beginning. So if people have questions, please use the Q&A feature on your screen and type the question up. So we have a couple of clarifying questions. If you may answer them, I'll read them to
Sure.
you, and
Okay.
and then I will go into the next part of the
Okay.
presentation, basically about what should we do about the bill. And then I have my own questions for you as well,
Okay,
if you don't
good.
mind.
I like
Okay.
questions. I like hard
Okay.
questions. I hope somebody have hard questions for me.
Okay. So, a question under C9, if I am charged with nuisance and the police now add the hate crime charge, does the charge of hate crime have to be proven in front of a judge?
Okay, so yes, it does. So if you're charged with nuisance, and to be clear, nuisance, that's section 430 of the criminal code. That's a section under which the police can, if you're protesting outside any place, they can always claim that it's nuisance. A very broad, loose definition. It gives police huge discretion. So it's very possible to be charged with nuisance. So uh, those protesters in North Toronto, pro-Palestinian protesters who were against whom a lot of vilification took place, could be charged. Some of them may have been charged with nuisance. So you're right. Under this provision, it could be they were engaged in a nuisance that was motivated by hatred. So they're now charged both with nuisance and with a hate crime. And both of those have to be proven in court in front of a judge. But as you know, you can spend a long time having been charged, having your life interfered with, having to put up bail long before you get in front of the judge. And then you have all the costs, the legal costs. So even if you win, the whole process becomes, in a sense, the penalty. So the fact that, yes, you do have a right to appear in court, um, and have a right to be legal defense and so forth, isn't so much the issue as this. There, if you're charged with nuisance, there's one trial. If they want to raise you were motivated by hate during that trial, they can. It doesn't extend the trial. It doesn't meaningfully extend your legal costs. Whereas the new arrangement will double all those things. And even if the charge is not upheld, you can pay a significant penalty because of this new option that Bill C9 creates.
Thanks, Jim. And then there's a quick question about would this law survive a charter challenge?
Well, it's always uh, a not very safe thing to do to try to prejudge what a court is going to decide. Um, uh, I think that being able to arrest someone for creating a state of fear when they have not engaged in any illegal activity. In other words, they haven't pulled out a knife, they haven't threatened a person with violence, they haven't harassed them because it's against the law to harass somebody. They haven't done any of those things. They just, as an example I gave, said, "Shame on you for going to this meeting," in a loud voice. I think if somebody gets charged, if the law is used as it can be used, I think we'd win a constitutional challenge to it.
Then another question says, if I display the Shahada, which is the declaration of faith in Arabic,
Right.
which is also included by, which is common in the Muslim
Yeah. Yeah. Yeah.
tradition, which is also included by flags of some designated groups, terrorist designated groups, can I be charged with a hate crime?
Well, I mean, first of all, no matter what you do, you can be charged with a hate crime. That is, uh, as we know. I mean, there's police can charge someone oftentimes for legitimate reasons, oftentimes with not, in my view, legitimate reasons. So yes, you can be charged. This bill, which is now law, makes it easier for you to be charged because of the provision that it's not only a display of one of the symbols, but of anything resembling that's similar to one of the symbols. So if the text that is being displayed is also the text that's on the flag or an artifact of a group on this terrorist list, the argument we made is that you are displaying and I'm quoting the words, a symbol that so nearly resembles the symbol described in paragraph that it's likely to be a symbol associated with the group. So yes, it increases the likelihood you could be charged. Whether you could be convicted I would hope a court would not convict you. But again, you would have to go through the whole court process with all the expenses and so on. So it's little comfort to know that, yeah, you'd probably win, but in the meantime, you could spend $50,000 in legal fees and have your life disrupted for months.
Yes. So there is a question about will this be applied to events happened before this law was approved?
I don't believe it can. I don't think there's a retroactive clause in this. So
No, there
no,
is not.
this only will apply. It's received royal assent. I'm not sure if regulations have been written about with regard to this and how if any regulations that might apply. But it could,
I saw a 30-day like that they're going to be implementing it in 30 days after royal assent. So I
right.
think this is the framework. Yeah.
So I think you can safely assume that in the very near future, this law will apply.
So I'm going to tweak the next question a little bit so that to take this answer into consideration. So the question here is, can we speculate how the legal proceedings arising from something similar to the protest at the Toronto chapter's Indigo would have changed had Bill C9 been in effect back then?
Well, yes. Okay. So this was a case where protesters poured paint on the front of an Indigo store, protesting the Indigo owners' Zionist activities and so on. So it was a symbolic protest. What the bill allows, because of the provision that if you violate any provision of the criminal code or any act of parliament, and it's motivated by hate, you're committing two crimes. So pouring paint on a building is an offense. Now, when it's symbolic and so on, a lot of us engage in civil disobedience and so on, so it's an offense, but it's a relatively minor offense. But what this law does is change the balance enormously, because even though you engaged in a minor offense, because they would argue you were protesting the owner's pro-Israeli activities, therefore you were engaging in hateful activities, therefore you were engaged in a hate crime, then you can face even more severe penalties than you would for the first one. So yes, it ups the ante considerably with regard to those kinds of protests.
Okay, so we'll take this last one and
Okay,
then we'll shift to the second part, which is also quite important because I think it's important to shift people attention of what can they do at this point
exactly.
and the kind of engagement we need to do. So
In
the
fact,
question here,
if I could say, I think that's the most important
yes,
part of this discussion because it's what
yeah,
we're going to do about this. We can't just
exactly.
come back and let it happen.
Right. So what penalties are we looking for in terms of length of time being detained in a case where we are charged with a hate crime and prepare to mount a charter challenge? So I think these are two separate things, but
That's right.
the question is the timing, the length of time being detained in case we are charged with a hate crime.
I can't answer that question. How long it is varies enormously by jurisdiction and part of the country, how busy the courts are. I mean, we've all been reading in Toronto about people being held in provincial jails for a year or 2 years while awaiting their case on trial. So it can be a substantial period of time. Courts are really busy in Ontario, especially Southern Ontario. They're less busy in Prince Edward Island. So there can be a reasonable variability in the time to your before your case comes to court.
Yeah, and then if the question is also about the sentencing, there's a whole table about a table of charges,
That's
sorry,
right.
of sentencing according to the type of offense
Yeah.
that this is coupled with.
The general pattern is they look at what's the maximum term under the first crime you're accused of committing, the shoplifting or the robbery. And
Yes.
then they tend to make the penalty for the hate crime, the second crime, uh, a bit longer than the first one.
Yeah.
So if the first one had a maximum term of 2 or more years, the maximum term for the second one is 5 years.
Second
Or
one meaning the hate offense.
the hate offense. That's right.
Yes.
So the first offense you're charged, if the penalty for that is 5 years but less than 10, the penalty for the hate crime is 10 years. And if the maximum term for the first crime offense is 14 years or more, the maximum term for the hate crime is life imprisonment.
And they're consecutive, right? They're not. Are they concurrent or or the judge decides?
The judge decides that, I think.
The judge decides. Okay. Okay. Thank you, Jim. So we went in depth into the legislation and the impact of this legislation. I just want to make a few comments on also that on the legislation itself, and Jim can explain more. So because there was a big debate about the removal of the Attorney General consent, which is one of the things that advocacy managed to remove that change that they wanted on Attorney General request consent with regards to hate propaganda. However, um, all the new offenses that exist in this legislation do not require Attorney General consent.
Right.
So the intimidation, the obstruction, and the new hate offense do not require a special Attorney General consent, which makes it almost entirely at the discretion of law enforcement to charge up until it gets to the court. The only offense that requires Attorney General consent is the hate symbols because it still falls under the Hate Propaganda Act. And Jim, if you want to correct this.
Yeah, I mean, if I just the point you just made is an extremely important one. In Canada, our courts have recognized, that's why they've made a very high bar for what's illegal hate speech, have recognized that in a democracy, especially in a really heterogeneous society, we all have very different ideas as to what's desirable and what's not desirable. And that a democracy, what's unique about a democracy is that we solve differences through discussion, argument, and debate, not through violence. And therefore, given Canada is a very heterogeneous society, our courts have said we have a very high bar before we shut down expression, before we make it illegal. And the kind of expression that's the most important of all is political expression, because that's what makes our democracy work. If I think a law is bad, I can be very strong in my condemnation of it and in my actions. And there are limits. I can't engage in violence. I can't engage in threats of violence. I can't defame someone. I can't engage in harassment. But I can be very outspoken and very critical. I can be angry. I can yell. I can use swear words to express my views. And our courts have said that's the price of a democracy. Salman Rushdie, in one of his comments, captures saying the heart of democracy is argument. So our courts have been very careful to try to protect our ability to argue, our ability to protest, our ability to have differences. And so one of the things is when the hate speech laws were brought in, they wanted to ensure that they just weren't cavalierly used. Because, as we know, various lobby groups would love to have all sorts of speech made illegal or treated as hate, or wearing a keffiyeh, or, I mean, a variety of things could be defined as illegal. So what they said is, if you're going to charge someone with hate speech, the Attorney General, as you were saying, has to approve it. And that prevents the police gratuitously charging people or a local Crown attorney being too aggressive. It provides some protection against the cavalier use of this restriction of our rights to peaceful assembly and protest and expression. And this bill got rid of that for all hate speech. And it was largely a result of your work, your organization's work, and the Canadian Civil Liberties Association and others, that was put back in, as you said, for the hate speech provisions, which includes the simple, but it was not put in for this creation of the new crime. So that can be used quite loosely and is a real danger.
Right. Yes, and just to follow in terms of also additions that were not at the heart of this legislation that also poses challenges to how Canada operated and how communities exercised expression. And that's part of the deal between the liberals and the Bloc Québécois when the Bloc introduced an amendment to remove the good faith exemption from the criminal code, which basically, in effect, limits the intervention of the state and law enforcement in the interpretation of
Right.
religious text or religious speech. That was the intent of doing it, and for over 40 years, this exemption was quite successful in limiting or almost not actually charging anybody on the basis of this because of this exemption. So because of that deal, the liberals voted for and allowed to include the removal of the good faith exemption from the criminal code, which in effect also is contrary to what they claim to be protecting with this whole bill, protecting places of worship. And it actually caused an uproar in faith communities, the Christian community, the Muslim community, and many other communities, basically because simply it opens a can of worms and a door that was closed for a long time. And that's basically anybody can claim that these take partial stories or take partial narrations or partial text and basically project it and claim that it promotes hate. And then again, as you said, it is probably going to be blocked it's going to be shut down in court. But unfortunately, the whole process is going to be that cause that chilling effect along with the PR damages associated with this.
Right.
The government came back with an additional explanation, 11.1, basically trying to say that um, the intent is not about critiquing religious speech. However, they unfortunately kept a condition, basically, unless it is done with the intent to promote hate, which basically brought us back to square one, where the interpretation of that hate intent is still uh, at the discretion of law enforcement, which again brings them back into the scene unnecessarily. Unfortunately, even after the government got majority before the vote on this bill, on the third reading, and then the final vote, they refused to make either removal the whole thing or make the language tighter by removing that condition. Um, and and unfortunately, and this takes me really to the question that I wanna have you answer and then move into the advocacy piece. Um, uh, that this was a simple political deal between the bloc and the liberals to make this change in a context where this whole entire bill is part of a political promise at the campaign of the Prime Minister and the Liberal Party. And even though it has significant impact on faith communities, the party prioritized, or the government prioritized that relationship with the opposition and with the Bloc Party over a major change in rights. And as you were explaining the different pieces of the bill, this bill is changing, first of all, the approach to dealing with hate from dealing it as a hate propaganda or hate speech to direct hate offenses, which is new in this in the Canadian context. In terms of the vagueness and the discretion, basically the whole environment around speech, around organizing, around freedom of expression is actually changing with this piece of legislation. It is actually, and I hope to. This is not happening in a vacuum, also because there are other legislations that are being put forward that are changing the basics of or the protections that we have for our rights and freedoms for specific purposes, whether it's political or otherwise. I don't
Mhm.
know from your experience going through all this, What's your reflection on this, and where do you think this is going to lead us?
Well, if I could pick up on the last thing you said, Ali, because I agree completely. Um, I haven't seen a government in the last 40 years in Canada that has brought in more legislation that undermines basic human rights and civil liberties than the Carney government has in the short period it's been in power. If you look at Bill C2 and C12 with regard to refugees and immigrants, if you look at Bill C5, which gives them the power to overwrite the rights of Indigenous people and override all the rights we have under environmental legislation in order to engage in economic activity. If you look at Bill C22, I mean, there's just a whole fire hose. And the Prime Minister was quoted as saying one of the surest ways to get a whole bunch of change happening is to have a fire hose of bills. And you're absolutely right. Bill C9 is part of that fire hose of bills, which makes it virtually impossible for all of us as civil liberty organizations to deal with one bill after another, after another, after another. And they go through Parliament so fast that there's not even a legitimate, careful study of them. And if there's a demand to study them carefully, the government imposes powers it has to shut down debate. So I think that the one good thing for us is I think they've overreached. And that's where I think we have a reasonably good opportunity in court to deal with it. I think certainly the provision about creating a state of fear being now illegal will not stand up to constitutional scrutiny. I'm not sure that having gotten rid of the protections for religious expression and quoting and so forth, I'm not sure that will stand up under challenge. They've gone so overboard. And I just I want to stop because I want the part you're about to talk about is really the key to this whole meeting. I do not think there's a single thing in Bill C9 that leaves us better off than we were before. And there are a lot of things that lead us worse off. It's very rare for a bill to have no redeeming value whatsoever. And I think that's the case with Bill C9.
These are very powerful statements, and especially coming from you, Jim. I think I think the at some point the government should and the Liberal Party in general should take a pause and actually look at what is actually being changed in Canada and the environment that these bills are producing. And I want to start from here. So basically, if the government is um, if we take the government at face value, at what they actually say, that the intent is really protection of communities, protection against hate, fighting hate, the rise of anti-Semitism and the rise of Islamophobia, and these which are very legitimate concerns, legitimate social issues that needs to be dealt with. We still see significant problems or concerns. Um, and they're not new because in democratic societies we see this trend. Once you start to expand state power, to expand law enforcement powers, you start to see an abuse of these powers, and you don't have enough opposing forces or checks and balances that basically allows for basically for the fulfillment of for maintaining our rights and freedoms. So that's the first thing that this institutes, even if the intent does not exist, the fact that you allow for it is there. And second, um, and that's a point actually I brought up with the Prime Minister directly. Combating hate legislation creates a framework, creates the limits, the upper boundaries for combating hate, and like basically these are the limits that society should not cross but it actually does not solve the problem. You did not have the legislation yesterday. You have the legislation tomorrow. You might feel that this will be a deterring factor for people from because you have offenses. But as you said, offenses existed already for all the charges that are to be made. So basically, there isn't anything. There is no new deterrence except that you're scaling it up a bit. And we all understand that the root causes for hate are much deeper than basically to be dealt with a legislation or the notion of deterrence. There are ignorance factors, there are intra-community tensions, there are political factors, there are many factors that lead to there are as we saw even in recent cases there are psychological factors and uh, some uh, some mental health pandemics that are due to other existing societal issues. So there are root causes that are worthy of exploration before we just rush into legislation. So that's and then the second is in your attempt, especially as a government with executive authority, you have the most authority to do things, to put resources in place. The society has entrusted you with actually coming up with problem solving and to deal with these issues. So what are the programs that are put in place to combat hate? What are the communities that you brought together in order to address these issues? What are the systemic issues and the systemic racism that exists that further adds to the polarization and adds to the societal tension? And then what are the political measures that you have taken in order to dampen and reduce these tensions? So these are all precursors to changing legislation or to rushing legislations and other real solutions that could be put. What are the kinds of consultations that you brought forward for communities to actually address hate and not just consult on specific new legislation that you would like to take? And from experience in other parts of the world, really over legislating adds to the tension, unfortunately, and overcharging people and filling the courts with cases actually delays justice. It does not actually help with. It does not help with resolving a deep societal issue that exists actually, and this is why we're attempting to do it. So that was not done ahead of legislation. So I believe that this is the first step that you do now. If this is your true intent, if the government's true intent is to deal with hate, I think we have an obligation now and a responsibility. And part of the advocacy that we should do is to take the government to account on their plan to combat hate away from legislation. Okay, so you have your legislation, you created your upper boundary. Then part of our advocacy is now, okay, tell us how you're going to deal with hate and how are you going to put programs in place. Two, and we started to do this from day one actually, is to actually we're gathering and collecting everything that the government has said in the preparation for this bill and in the discussions and in the committees and in the media to show intent for the implementation of this bill, right? And you can correct me here. And we believe that this also might be helpful when this is taken in cases that are taken to court, because the judge will decide if this is how the law enforcement actually applied the bill according to the intent of the legislator. So we're actually putting this together in order to show and to basically to take the government to what they actually have committed to. So this is not about policing protest or limiting protest. This is actually about hate intent and hate motivation. And what do we mean by that? So that's number two, which is basically we actually want more politicians on record who believe that this bill is not against freedom of expression and is not against freedom of assembly, to actually come forward and make sure and assure society, communities, that this is actually not done for this case, and this is even post the issuance of this bill should be the government's commitment to do so. And that's the second one. My third point is, so now on implementation, because now the bill allows law enforcement to like much more discretion. It is actually on the government and now on multiple levels of government to add more checks and balances to the implementation and to the use of this discretion, right? So according to the intent that the government has outlined. So the government should show us how is that going to be communicated and pushed through the different levels of government across different agencies. How is this? How are you going to assure us as a society that C9 is not going to be implemented or misused or abused? So the checks and balances that are put in place. I had a very fruitful conversation today with an liberal MP who was concerned about who had initial concerns, but then the government gave him a narrative, and then he said, I agree with the premise of the responsibility of the government to engage with law enforcement and put checks and balances. And he suggested in his locality to initiate dialogue and training to law enforcement so that they are in line with what the government intended to do so. And that's something, again, that is commendable. And we hope to see this at scale. And then the fourth is what CCLA, Canadian Civil Liberties Association, started again immediately after the implementation of after the approval of the bill, and that's basically creating a monitoring tool. Okay, and we as civil society, whether or in organized institutional capacity or even on or people's in the individual capacity, we should be the protectors of our rights at this level, and that's through monitoring. If we need to report how law enforcement is going to tackle this to change their behavior. How are they going to extend their authorities? And we actually need to report as much as we can. So monitoring and reporting is now becoming a societal responsibility. And organizations such as CCLA and other organizations, we're going to be also supporting the monitoring that CCLA does, and expanding ways to do this monitoring. But all of us need to be part of this process. I also think communal and collective efforts should be now put into legal funds, for example, because now this bill allows for more charging. First of all, the limitation, so the lack of Attorney General consent, for example, means automatically means that we will have more charges on even the same issue. So we gave the example of in Toronto protests over 2 years post October 7th. There were 183 charges, according to one of the organizations, from related to protests. Half of them were dropped by the Attorney General. Half of them were dropped by Attorney General because they were not complete, which means that that automatically, if the Attorney General step does not exist, then there will be much more charging there, and which also means that collectively we need to build more capacity to support those who are going to be those loud and of course we never support violent voices or violence or people who promote hate and stuff, but those who engage in legitimate dissent, whatever their opinion is, should actually be supported because they are protecting the very essence of our democracy and our right to engage in healthy debate and diverse political opinions, allowing for diverse political opinions. So I think building capacity to sustain them until it reaches court or until we get a charter challenge and so on, and then finally the point that you mentioned, and I'm saying this as finally because this is going to be a lengthy process, and that is the charter challenge to the bill or to the implementation of the bill, because as you have explained to me ahead, is that this requires a significant application that involves abuse of people's right, and then it takes its course until it reaches court, and then we can use this case to as a case towards a charter challenge. So that's a lengthy multi-year process. And in between the chilling and the culture change of what our youth are entitled to do, what activists are entitled to do, is actually going to be impacted, is going to be severely impacted. And the sad news here that even though the government has issued this in the context of October 7th, promises to specific communities, the language is not specific. So actually, it potentially can impact any community engaging in a similar dissent. If people are protesting the pipeline development in the western parts of Canada. Similar, like basically the bill allows for this being applied in an environmental context or in an indigenous context. It is definitely, I've specifically asked Justice if there's exceptions for labor, for example, labor unions and picketing. Yes, the current application, we will not see this immediately, but it allows for this to be used in other contexts, including labor union protests or labor organizing in general. So there are no limitations. And for example, in the example you gave about it's not even limited to places of worship as this was intended to be. So basically, any building that is used in part or in full by an identifiable group, not even for religious activity, for any type of activity or for most activities, educational, sports, or otherwise, as the legislation implies, basically just broaden this application to anywhere in Canada, schools, parks, community centers, if they were used in part or in full. So honestly, and then at the end of the day, it's not so vague that basically this will the how this bill application is going to be shaped by how it's going to be used. And that's really the conclusion that I would like to make. We can't be silent. It's not that we lost the entire battle by that the bill came with very minimal changes. No, actually, it is the opposite. This is actually the where we have to get louder. One, we have to tell the government and express to the government that we are not happy with the outcome at this point because the outcome directly impacts our freedoms. This is how we view it. So the government should feel that this actually costs them some political credit and some that happened through the campaign, but even after the fact, that it's not just a done deal. And if they can change it, they should attempt to change it or review or put safeguards. We should organize to make sure that as I said, that the application, that there are safeguards for the applications. And we should organize basically and educate so that the implementation across Canada does not go out of the initial commitments that the government has put forward. And then finally, we should organize to support one another, whether it's legally, whether it's in solidarity or in support for those who are going to be impacted, wrongly impacted by this bill. And I think that the coalitions that we started and the alliances that we built together should continue, because if let's say the pro-Palestinian advocates are now being targeted now, soon, whether this government or later government, other groups might be impacted. This is a change to our criminal code and impacts directly our Charter of Rights. So I think this coalition against this attack, whether it's C9 or others, should actually continue beyond this. And one of the things I noticed and observed as we do this organizing Honestly, this is a time for Canadians to wake up at scale, and it's not just the activists or the human rights community or the civil liberties communities. We are taking our rights and our freedoms that we enjoyed for years for granted. And these are the kinds of governmental overreach, as you called it, that erodes away of our rights and freedoms. It is not going to stop on the goodwill of the government because it enables them to have more control. And that's the nature of the government. It wants more control. The only thing that is going to stop that overreach and that erosion of our rights is that we feel that the Canada that we enjoyed is actually changing and more of us are speaking up. So I feel that this is a moment, a wake up moment for Canadians, not after the fact, after this is wrongly implemented, but initially, but now that a movement to preserve and protect our freedoms should start and should begin and should organize in order to really put a pause and protect the Canada that we enjoy, the Canada that we people find safeguard or find safe haven in because of this, because of the Charter of Rights, because of the respect of the different institutions to our charter, and basically the culture, the collective culture of freedoms and rights that we enjoy. So these are a few items that few pointers that I wanted to share with everyone. We are going to commit to organize along these lines, support CCLA monitoring. We're launching an awareness campaign. Today we launched an infographic on our socials, basically showing how much what was done collectively through this coalition, and what needs to be done moving forward. So awareness is something that people can engage in and be part of. And also, we're committed again to support the legal advocacy efforts of ex-legal experts like yourself, and other organizations such as CCLA. So I will pause here and pass it back to you if you have any comments on these list of suggested actions or concerns, sorry, or pointers for advocacy that you feel is worth highlighting or focusing on.
Well, I was quite impressed with your list, Khaled. Uh, you identified the key things that need to be done. I guess there's just one other thing I'd emphasize, and that is the final check on government actions is the citizenry, is the public. And so what's critical when a government makes a mistake, as I think it is done here, the one thing that can hold them in check, especially in a parliamentary system, is we can turn to the courts, but ultimately it's the public speaking out. And so we have to really commit to not being chilled by these actions. I mean, to put it differently, excuse me, there's nothing that was wrong that wasn't punishable under the old legislation. In other words, the new legislation doesn't criminalize anything that should be criminalized. It's already been criminalized before this bill. What it does is puts up a bunch of things to scare people off and possibilities for them being, as we've said, unconstitutionally restricted. And so it's really important for those of us who believe that to speak out in whatever way we can about this bill and what's happening, whether it's talking around the dinner table, or if you're a member of a political party and go to a local riding meeting talking about it, or talking about it with your friends. That's how democracy is protected. I mean, you've just given a very eloquent description of what needs to be done at a time like this in a democracy. And unless we do the things you listed, we're going to be moving away from the democracy. This is a profoundly anti-democratic bill, as are some of the other ones that I mentioned that have come from this government. And if we want to preserve our democracy, then we have to speak out in all those ways. And the first way is simply not to be intimidated ourselves, to continue to exercise what we think are the legitimate rights of Canadians and those who live in Canada, and to continue to exercise those rights, and to count on the fact there's going to be organizations like yours and mine and others that are going to support them if they are challenged for exercising their rights. So I think your list of what are the, asking the government what are the programs that they're going to bring in to get to the root causes, because you don't solve hate by putting people in jail. If anything, you make them angrier. If we're going to deal with hate, as you say, I mean, part of it is ignorance. So there has to be an educational component. And there has to be recognition that other parts of it come from psychological difficulties. So our total unspending on mental health makes the situation worse. A lot of it grows out of political differences that we have to find ways to allow them to be expressed that aren't criminalized so they can be worked through. But there's another cause of them too, and that's the enormous economic inequality in the country. When people are poor, when they don't have access to what they think are their rights, they can become angry, they can scapegoat others, they can blame it on migrants, they can blame it on recent immigrants. So we have to deal with the inequality. I mean, there's just all this work, most of which you identified, that has to be done if we're serious about solving these problems. And unfortunately, legislation like this diverts the energy and money of the government into building more prisons, having more courts, having more judges when they're going this route, rather than putting that money into better education programs, better mental health programs, better opportunities for differences to be worked out, and creating a more egalitarian society. It just, I mean, we're following in some ways the example of what the Americans started to realize. As you know, the Americans had the highest percentage of people incarcerated of any country in the world. I mean, dramatically higher. Bills like this take us along the same route. More people are going to be in jail. We're going to have more jails. We're going to spend more money on our criminal justice system. That never solves the problem. Because if it did solve the problems would be one. I mean, there would be no problems in the United States. It had twice as many people in jails as almost any other country. So I'm really grateful for your listing of all the things that need to be done, and certainly our organization would love to be partners with you in working on doing those things. I think you're providing the very kind of leadership that's vital in Canada at this moment. Could I just mention one other interesting fact that suggests it's not just you and me who think that a bill like this is unnecessary. I was very involved in the debate in Toronto about the adoption of a bubble zone bylaw, like the provision in this one that prevents protesting within certain distances of religious facilities or other facilities. Do you know who was an ally of ours in opposing the bill? The Toronto Police Department. They said, we already have the authority. All the things that you're talking about here, all the legitimate things you're talking about here of obstructing people, threatening people, of harassing people, are already illegal. We don't need another bill to deal with the issue. So it was interesting. It was the Toronto Police Service also said this is unnecessary. Now, they didn't get into the discussion of Bill C9 at a federal level, but certainly when it was talked about Toronto doing its own municipal version of the same thing, they agreed with us that it just duplicates what's already illegal. We may have an enforcement problem, but we don't have a legislative problem. And having more laws and more time in jail, there's no evidence ever that solves the problem. And yet it's a politically popular thing to do. It's an easy way out for a government who can tell those who are lobbying them to do more about whatever form of hate they don't like. Say, well, look what we're doing. We passed this bill. We're doing all these things, when in fact, they're actually harming the situation. And that's where speaking out, as you're suggesting, as you've been doing, and as your organization's been doing, And suggesting all the rest of us have to do more of that is exactly the right thing.
Thank you, Jim. We have I know we promised to finish around in by 8:30, but let's try to tackle a few questions that are put on the Q&A, and we can just do quick answers. So, the first question is curious to your thoughts on any parallels between how Bill C9 may be enforced and what has been happening in England in respect to Palestine Action, arrests of protesters, and the outcome of the recent trial of those who were involved in action against jailbait systems.
Well, I can give a quick answer to that. It's going to be enforced differentially across the country. Whenever you have a law that is vague, you give discretion to the police, as we're talking about it. So in some jurisdictions, the police are going to behave themselves and enforce it narrowly as it should be enforced. But in other places where they're under pressure or where there's powerful lobby groups, it can be enforced in a way that causes all the problems we fear are going to happen. So we're going to see enormous variation in the enforcement. And that's one of the things that's going to help the courts consider that it's unconstitutional, because laws are supposed to be written in a way that you know whether or not you're violating them. And so routinely, laws are tossed by courts when they're overly broad or overly vague. And there's elements of this bill that are certainly overly broad and overly vague. But until they're tossed, they leave a lot of discretion. So we're going to see a lot of variation in how it's dealt with across the country, I'm afraid.
So I'll take this next question. What guidance are you proposing to the MP that they will want to implement in terms of police training? Would be helpful to know what concrete asks to mention in our meeting with our MPs. So I would suggest, so the general for the MPs is that the government issued, like the Parliament issued the bill, and the MPs can be involved in the guidance on how this bill should be implemented. So if you're talking about expansion of basically engagement with law enforcement, so encourage engagement with law enforcement to attempt to understand how do they understand the bill, what does it allow them, how are they going to implement it differently. Maybe even you can get into how do they view the IHRA definition, because it might play into the mix related to the definition of hatred, like how do they define hate and hate incidents, and especially in different localities, like what's the police figure. So there is an engagement factor, and if you can encourage for consistent engagement with law enforcement, so it's not just on after the fact, like ahead of the fact in terms of awareness. And then you can reach out to organizations like ourselves or NCCM or CCLA and others in supplying you with material that can be used as referential for if you referred specifically to police training and awareness as it relates to the implementation of this bill. So there is much room for continued engagement in this. And I say the sooner you do this, the better, because once there is tension, it becomes much more difficult to engage in genuine training. With regards, so next question, speaking of monitoring and reporting, have submission pages been up for the public to alert orgs? Even if not dealt with case by case, it would give our orgs invaluable data. Go ahead, sir.
I was going to say the Canadian Civil Liberties Union, or Association rather, has begun talking about having a reporting mechanism. I think it's going to require an effort of a whole bunch of organizations working together to have right across the country an opportunity for anyone who's negatively affected and, in their view, improperly affected by this legislation or other equivalent legislation to be able to report that. Because if we're going to challenge it in court, the best way to challenge it is when we have actual examples of its misuse. So it's going to be vital that there be this cross-country opportunity for every Canadian to know where they can report if they've been caught up in the web of what it looks like an inappropriate bill or an inappropriate law, to be able to report that, and for us to investigate that and use that in helping planning our challenging of the bills.
So I also am putting in the chat tracker form that CCLA has produced. So this is a starting, and as Jim mentioned, this will require a collective effort because organizations might be monitoring specific aspects of the bill.
That's
We
right.
need to have a whole culture of monitoring and making sure that law enforcement is aware that we are monitoring. So
Exactly.
that they're very careful about it. And like even with these simple things, that when you see the fact that you take videos of incidents and things that are happening, all are very useful tools in court in general, but also in the court of public opinion.
Right.
So I put the link to the
Sure.
CCLA's. Yeah, it's on their website.
Good.
Can we now push government for more legal aid funding?
We can, I mean, the short answer to that is we certainly can push them. Whether they'll do it or not is another matter. But given they're creating so many more people who are going to be charged, arrested and charged, they have an obligation to increase the pool of legal aid funding. It's desperately low already, as most Canadians know. So one of the priorities we have should be to increase funding for legal aid.
Um, so there's a question about removal of this bill and mount a charter challenge. Are there any ways to remove the bill other than charged in a different jurisdiction or mount a charter challenge there? I think it's already in play. It's already legislation. So the only way is whether the government decides to remove it, like the government decides to come up with another legislation to remove this legislation, like another parliament act, or the courts. These are the two
Well,
ways.
there's a third option, and
Hmm.
that is to create so much opposition to it that one of the political parties in the next election with a promise to uh, remove it and to have them elected. I mean, that's what a
Yes.
lot of Americans are hoping will be the antidote to what Trump has been doing. Is there'll be another government that will take a different position than his. I mean, that's ultimately the protection that democracy affords to everybody. It's just a
Yeah.
slow process.
Yeah, and the example in the UK is even prior to the next election. So
That's
as
right.
Starmer just resigned because of all the bad decisions that he has made, and I think it will force the next PM to make a different approach.
I mean, that's a really important point. You often don't have to wait to the next election if the government in power has a sense they're going to lose
Mm,
because of this. They may do it to prevent their loss. They may
right.
do the right thing.
So there's a question: who asked for Bill C9 and who advocated for it and why? You can automatically tell
Well,
when you see who celebrated it right after.
well, I mean, there have been a number of groups that have been very openly in support of it. The Council for Israeli and Jewish Affairs (CJA) has been prominent. B'nai B'rith has been prominent. Many pro-Israeli, pro-Zionist groups have felt that this was really important, that they're concerned about anti-Semitism, and they see this as a solution. I think they've been the most prominent supporters of this legislation. We agree there's a problem. This is just the wrong solution to the problem.
Thank you so much, Jim. Just a last question here is the fact that there is political motivation or political lobbying or foreign interference might be useful for the Charter Challenge.
No, I mean, if you take almost any big issue in Canada, there's wild differences amongst the population, arguments and so forth. And, if we're going to charge anybody with foreign interference in Canadian affairs, there's one government that's had more interference in Canadian affairs than all the others combined, and that's the United States because it's our neighbor, it's so powerful, and we're so integrated with it. No, I mean, this is something we're doing ourselves. We have to take responsibility for it, and we have to, as I think you so elegantly discussed, have to take the leadership in helping Canadians understand why this is the wrong way to go. We can't blame it on outsiders. We have to do the work or the democratic work of persuading our fellow Canadians that this is the wrong way to solve problems. There are problems, and what we want to focus on are the right ways to solve the problems.
That's a great place to end, James, that we acknowledge the existence of the problems and we want to be part of the solution collectively. But we just feel that the government went about it in the wrong way, and we need to really damage control and minimize that. And this will only happen with collective awareness and collective action to just make sure that this is really narrowly implemented or implemented in a good way. And with this, I really thank you, Jim, for your time, for your insight, for your expertise. You've been always the wise person in the room, and you made time
Well,
to go back to and get your advice on legal issues and on advocacy. And it was really a great opportunity to work with you on this on this legislation and otherwise. And to everyone, really, I come from a place of diverse experiences around the world, and I tell you that we truly love Canada for the rights and the freedoms that we enjoy and exercise here. And it is really a very special place because the whole society appreciates it and appreciates the diversity and the differences and the political debate that exists. Like, this is what we enjoy most about Canada. Other countries have taken an authoritarian path that basically take this away. And we should not take this for granted, and we should do our part and preserve it, not just for us, but really for the next generation and for our children and grandchildren. We'll do our part, and we look forward that everybody does theirs as well. Thank you so much again, and we'll connect soon in other venues and other opportunities. And I left our handle at CMPAC online, and Jim is also reachable with the Center for Free Expression. And we will continue to do what we can, and we'll stay in touch. Thank you again for joining, and we'll keep you posted. مع السلامة. السلام عليكم.
good night, everyone.